students, myself Pinky Singh, Assistant Professor of IMS Law College, Noida. Today I will tell you about the essential conditions for a valid contract. These conditions are available under the Indian Contract Act of 1872. So, specifically, what is contract or what are the essential conditions for making a valid contract? I will tell you. So, what is contract? Sir William Anson defines a contract as a legally binding agreement made between two or more persons by which rights are acquired by one or more to acts or forbearance on the part of the other or others. Or we can say, in other words, a contract is an agreement between two or more parties which is intended to have legal consequences. So, what is a contract? Contract is an agreement between two or more persons which is intended to be enforceable at law and is constituted by the acceptance by one party of an offer made to him by the other party to do or to abstain from doing some act. Under the Indian Contract Act, Section 2, Subclause H defines a contract which as follows: an agreement enforceable by law is a contract. So, according to this definition, what it implies? It implies that a contract is a legally enforceable agreement. Thus, a contract consists of the following two elements: agreement first, and second thing is legal obligations arising out of the agreement. So, here I will tell you what are the essentials of a valid contract. All agreements are contract if they are made by the free consent of the parties competent to the contract for a lawful consideration and with a lawful object and are not expressly declared to be void. Like I said, all agreements are contract. What is agreement? It is defined under Section 2, Subclause E of the Indian Contract Act, and it defined as every promise in every set of promises forming the consideration for each other. So, in other words, we can say an agreement consists of offer, means proposal by one person, and its acceptance by another person to whom the offer is made. So, it means we require for making a contract the plurality of persons, two persons. And for making a contract, what we need? We need some essential requirements which make an agreement into a valid contract. So, there are some legal requirements, or we can say some essential conditions to make a valid contract. First one is the agreement, means offer and acceptance. Second is the legal purpose. Third one, lawful consideration. Fourth is the capacity to contract. Fifth, consent to contract. Sixth is lawful object. Next is certainty. After that, possibility of performance. Ninth is not expressly declared void, and 10th is the legal formalities. So, these are some essential requirements which I will discuss with you in our next slides. So, first requirement, the very basic first requirement is the agreement, means offer and acceptance. Means in order to create a valid contract, there must be a lawful offer by one party and a lawful acceptance of the same by the other party. Like I said earlier, that for an agreement we require the plurality of persons. For example, here I will tell you example that if A makes an offer to sell his scooter to B for rupees 5,000 and B signifies his assent thereto, it becomes an agreement between A and B person. Then the proposal may be for doing an act or for not doing an act or abstaining from doing an act. For example, I am again giving you an example. Second example, if a person makes an offer to B not to sue him for consideration when he, means A person, has reasonable cause to sue B, it is a contract. So, what we conclude that all contracts are agreement. Okay, the adjective lawful means offer and its acceptance must conform the rules laid down in the Indian Contract Act regarding the valid offer and acceptance and its communication. Second main requirement is the legal purpose, or we can say the legal obligation. To make a contract, an agreement must be enforceable by law. It means that an agreement must give rise to legal obligation. An agreement which gives rise only to social obligation, it is not a contract. For example, suppose if a person invites his friend to attend a dinner party at his home and he accepts the invitation, this agreement creates only a social obligation and thus it will not be enforceable by law if either of them makes a breach. And in this regard, there is a very famous case, Balfour versus Balfour. This was the case of 1919 and this was the case of England. In this, a particular defendant and his wife enjoying a leave in England, and where the defendant was due to some work, he has to return to his place where he was employed, and he advised his wife for some health reason to remain in England, and defendant agreed to pay some amount for the maintenance of his wife per month, but he did not send the amount, and because of this is resulted in their separation, and wife's action to recover the arrears was dismissed because it is only a social agreement, not the legal agreement which is enforceable by law. Next requirement is the lawful consideration. So what is lawful consideration? It has been defined in various ways, like it is the price for which the promise of another is bought, and it is also known as the quid pro quo, or means something in return. It is an essential element in the contract. Next is the capacity to contract. What is the capacity? Means the parties to an agreement must be competent to contract, means a contract by minors are void. So if you want to make a contract, you have to be above 18. If either of the parties does not have the capacity to contract, the contract is not valid. So accordingly, the following persons are incompetent to contract, like minors, persons of unsound mind, and persons who are disqualified by law to which they are subject. Okay, so this is very important. An agreement with minor is void. Now next is the consent to contract. What does the consent means? It means that parties must have agreed upon the same thing in the same sense. Section 13 talks about the consent, and this is also called the consensus ad idem in English law. Means what is the consent? Consent means the making a contract, and if you want to agree on the same thing in the same sense, it is a consent, and it must be free. There must be a free consent of the parties, and if consent is not free, if it is caused by, according to section 14, what section 14 says? It says that consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. These are the consent to the contract. Okay. Next is the lawful object. The lawful object, if the consideration or the object of an agreement is unlawful, the agreement is illegal or unlawful. So the particular consideration of the object of an agreement is said to be unlawful if it is forbidden by law, or it is of such nature that permitted it would defeat the provisions of any law, or it is fraudulent, or it involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. For example, sale of liquor without license is illegal. Next is the certainty. According to section 29, agreement, the meaning of which is not certain or capable of being made, are void. Means certainty is also a important essential element for making a valid contract. For example, if a person A agreed to sell to B 100 ton of oil, but there is nothing to show that what kind of oil intended and what kind of oil he want to sell, the agreement is void because due to the absence of certainty. And next example, but if A is a dealer of coconut oil only agrees to sell B 100 ton of oil, the nature of A's trade is sufficient to show that the kind of oil, and this will be a valid contract. Second is the possibility of performance. Condition for a contract should be capable for performance. If the act is impossible in itself or it's physically or legally, it cannot be enforced at law. For example, here I will give you an example regarding this. If A and B, two persons, makes an agreement that if B encloses a space with the help of two straight lines, then A will pay him rupees 1000, otherwise B will be liable for paying rupees 500 to A. So, what is the result of this particular kind of contract? Here I am telling you that A and B making a contract to what to do for enclosing a space with two straight lines, and this is a impossible work because two straight line cannot enclose a space, hence this contract is not a valid contract. Now next point is not declared to be void or illegal. So the agreement must not have been expressly declared to be void. The agreement, though satisfying all the conditions for a valid contract, must not have been expressly declared void by any law in force in the country. Agreements mentioned in section 24 to 30 of the Act have been expressly declared to be void. For example, an agreement in restraint of trade, marriage, legal proceeding, or similarly those agreements which is not certain or capable of being made certain, or an agreement by way of waiver, or an agreement to do an impossible act is also void. Next are the legal formalities. What are the legal formalities? If suppose the agreement must be in writing or registered, as the case may be, where so required by law, an oral contract is also a perfectly valid contract. But if somewhere it is required by some statute that it should be in writing or it should be registered, then you have to fulfill those legal formalities. In India, writing is required in cases of sale, mortgage, lease and gift of immovable property, negotiable instruments, memorandum and articles of association of a company. So, registration is required in cases of documents coming within the scope of section 17 of the Registration Act, and all these elements mentioned above must be in order to make a valid contract, and if any one of them is absent, the agreement does not become a contract. So a contract, to be a valid contract or to become a valid contract, an agreement to become a valid contract, it must be fulfill all these essential requirements, means it has to be fulfill all these essential requirements to be a valid contract. Now I am concluding here my discussion on the essential elements of a valid contract. So thank you.